Okay, good afternoon, everybody. It's just a little bit after 2 o'clock. We're going to go ahead and get started. There are a few that are still working on getting registered, but they'll join us shortly. This is Jerry, and I am with TruDiligence. And I wanted to just welcome you today to our webinar on FCRA adverse action processes. So we have, by virtue of GoToMeeting, everybody that is in attendance muted, and so if you have any questions whatsoever as we move through the presentation, you've got your GoToWebinar control panel, should be displaying on your screens. Just certainly type any questions into that questions box on the right-hand side. And I've got a relatively short presentation. It's about 15 PowerPoint slides, and we'll end with a question and answer section. So I'll do my best to leave plenty of time for us at the end of the presentation that I can run down the questions that have been asked and do my best to answer those in the time that we've got. Okay? So again, we are here today to discuss FCRA adverse action processes. So let's get started without further ado. First of all, just for a piece of housekeeping to get us started, it's always our favorite slide. Our attorneys made us do it. I have to put the disclaimer on this that we are, nor am I, nor is anybody at TruDiligence attorneys. Therefore, no communication from us that is oral, written, or otherwise is intended to be legal advice. Obviously, we always have to make the recommendation that you seek your own legal counsel's advice with questions that you have specific to your own situation. Nothing that we can provide to you is to be deemed as anything really other than just consulting based on our expertise within the industry. Okay, so with that to the side, just a little bit about me for those that are in attendance that are not clients and not familiar with me. My name is Jerry Nielsen, and I am the president and founder of TruDiligence. I formed TruDiligence back in 1993, so we have been operating in the background check realm, oh gosh, almost 25 years going on here pretty soon. We are Better Business A+ rated through the Better Business Bureau. We, as a company, are nationally accredited by the National Association of Professional Background Screeners. It's a badge that we're really proud of, as that accreditation is only awarded to a very small percentage of background check companies throughout the country. And so it was something we worked very hard at, and took us a couple of years to get and had that awarded back in January. And in addition to that, we are all, and I am, FCRA Advanced Certified by the NAPBS. So we have been through very, very exhaustive training on the Fair Credit Reporting Act and everything that it entails. So enough about that. Let's move in first of all to get started with just a few definitions, a couple of definitions that I thought were important. And some of this will be old school for many of you. Some of this might be new to you. So either way, we'll kind of touch on some basic points here in the terms of definitions and get everybody on the same page. So first of all, let's just talk about this FCRA thing that we're always referring to. Really what that is the Fair Credit Reporting Act. This is the piece of U.S. regulatory code that was enacted back in 1970, and it is the governing force for everything that we do as a background check company when we are servicing your needs on applicants in terms of background checks. It's a very common misnomer out there that the Fair Credit Reporting Act only addresses or regulates a person's credit report because it says credit in the title, Fair Credit Reporting Act. When actually, if you dig into the nitty-gritty of the Fair Credit Reporting Act, you'll find that when a background check is being pulled through a background check company or consumer reporting agency, as it refers to us, that Act governs everything that goes in the report. Yes, a person's credit, but in addition to that, also everything from driver's histories to criminal record searches to derogatory information that may be coming back through some sort of an employment or education verification. The FCRA also mandates the disclosure and release processes. also mandates the adverse action processes, for which we're going to be discussing in greater detail today. So it's just really important for everybody to understand that that Fair Credit Reporting Act is really where all of these steps are being driven by. So I'll refer to FCRA typically by short. Within the industry, that's probably how everybody refers to it and how you all would be comfortable with it as well. But again, that is the Fair Credit Reporting Act. All right, on to adverse action processes in general. So the FCRA has about 10 bullet points that it lays out in the text that define what adverse action is. Okay, I've pulled two of the ones that I think are most applicable to what we are doing for any of our clients, be that tenant screening or employment screening. Okay, so the first definition of adverse action, as comes right out of the Act, is a denial of employment or any other decision for employment purposes that adversely affects any current or prospective employee. That's pretty self-explanatory. So when the report is being pulled and it contains derogatory information that might adversely impact that person in the employment realm, FCRA kicks in, right? Because that is defined as an adverse action under the regulations of the Fair Credit Reporting Act. Okay. The second one that is also, I think, very applicable to us, and even in so many ways much more broad, is the second one I have here, which is any action that is taken or determination that is either one, made in conjunction or connection with an application that was made by a consumer basically, or an applicant, and that results in an action that is adverse to the interests of the consumer. This is where a lot of our tenant screeners fall. So we have a carve-out in the Fair Credit Reporting Act in terms of defining adverse action for employment, and then we have a carve-out that pretty much will cover everything else. You know, there are other carve-outs for insurance purposes and for financial purposes, but I really think we would be hard-pressed to find any possible adverse action that could be taken that wouldn't somehow fall under the guise of the second description, or definition. It is really, it's about as broad as it gets. So the reason I harp on this a little bit is we'll take calls oftentimes from clients that will say, well, I'm denying my applicant either for tenancy in a tenant screening realm or employment in an employment screening realm, and this is the reason that we're denying them. And they, possibly are kind of trying to find some way to overshadow the fact that it might have been because of the background check so that they don't have to follow the adverse action processes. And I always fall back to these definitions. It's like if you're using it and it's coming out of our report, it is likely going to fall under one of these two definitions. Okay? All right, moving forward. So we've got just a couple of key points here. One of the things I'll mention here is in looking at the registrants for today's session, we have a good combination of employment screening people that use our reports for employment purposes, and also tenant screening purposes. And so I'm going to do my best as we step through today to kind of blend the presentation so that it fits both needs. There are, you'll see in a moment, there are some steps that are specific to the employment realm, and there are some steps that will apply to both employment and tenant screening. I think it's important because I think even our tenant screeners obviously need occasionally to hire an internal employee, and so they may still fall under the guise of the employment purposes, and so I will do my best to blend those as we go through. So our first key point here is that the adverse action process is required anytime you are considering taking adverse action against an applicant, in general, an applicant, based on the contents of a consumer report obtained from a consumer reporting agency such as TruDiligence. Okay. The sub-point here is that adverse action is not required. All these processes we're going to go through as we step through the slides is not required when the background check is conducted in-house and not through a consumer reporting agency. Okay, so to break that down just a little bit, if you're outsourcing your background check process to TruDiligence or some other background check company, and that background check report comes back and there is contents within the report that are going to cause you to not move forward with that person's application, you must follow the adverse action processes that we're outlining here today. If you've conducted, in some fashion, an internal investigation, in other words, you called the person's employment references or landlord references, or maybe somehow conducted some of the credentialing, and you did that internally with internal staff and did not use a background check company to draw that information, and ultimately what you have found results in an adverse action against the employee or applicant or tenant, you do not have to follow the adverse action processes. Okay, so what we're talking about here today applies specifically to reports that are drawn through a background check agency, okay, or consumer reporting agency. Secondly, which we touched on a minute ago, is that the adverse action process is required and regulated by the Fair Credit Reporting Act. So as applicants, or even you have questions about where all this is being driven, we'll refer you back to the Fair Credit Reporting Act. And I'll have a little bit more on that here in just a little bit. Okay. Thirdly, for employment purposes, the adverse action process is a two-stage process. Okay, we have a pre-adverse action stage and we have an adverse action stage. Okay, in contrast to tenant screening, the adverse action process in a tenant screening purpose is only a single-step process, which is basically the adverse action itself. Okay, so as we move forward, I'm going to break down both of those two stages, pre-adverse action and adverse action. Okay, so as we go forward, let's start with pre-adverse action. Okay, as we indicated, this is unique to the employment purpose. So for all of our people that are out there that are employers doing an employment screening, this applies specifically to you. This does not apply to our tenant screeners. Okay, so the pre-adverse action kicks in when we get our report back from the background check company, okay, back from TruDiligence. And we've reviewed the report. We see something in there that is going to cause this person to potentially be ineligible to move forward in the process, okay? So where it kicks in is before you reject a job application, reassign or terminate a current employee, deny a promotion, or take any other adverse employment action based on the information in the consumer report that you've got back from your consumer reporting agency, you need to go through this pre-adverse action step, okay? Basically what that means is we provide the applicant a pre-adverse action notice. Okay, that notice goes out to the applicant, and basically the contents of the letter says something like this: we have found information during our background check, pre-employment or other employment background check on you, that may potentially result in a negative action being taken against you. Okay, here is the copy of the consumer report that we got back from our resource, our background check company that we relied on to make the decision. And here is a copy of the document that is called a summary of your rights under the Fair Credit Reporting Act. Okay, that document, that summary of rights, is a document designed specifically by the Federal Trade Commission and is required by the Fair Credit Reporting Act when you're communicating these adverse action notices to your applicants. Okay, so it's as simple as this. A packet goes out to the applicant. In that, there are three things. There's a pre-adverse action letter. There's a copy of the report so that they can see what information is concerning. And thirdly, there is a copy of the summary of rights under the Fair Credit Reporting Act. Okay, and that is all available through TruDiligence, and I'll touch on that here in just a little bit. So finally, let's talk just a little bit about really just the intent of the pre-adverse action step. Okay, so let's assume that the pre-adverse action is going out. Obviously, the intent of that is that the pre-adverse action letter helps to minimize the possibility of the applicant being denied employment or promotion without him or her knowing that they have possibly been the victim of either insufficient or erroneous information. Giving the person the notice in advance gives them the opportunity to review the report and tell you if it's correct. So it makes perfect sense that we're going to send out this packet to our applicants, and we're going to give them an opportunity to review the information that is going to potentially lead to their denial. Okay, so pre-adverse action goes out. All right. Applicant, if I can get me to move forward here. So then we go into this waiting period. Okay. When I say that employment is a two-stage process, technically it's a three-stage process. But for any literature you ever read about the adverse action process in employment refers to it as a two-stage process: pre-adverse action and then the actual adverse action. So I'm staying consistent with that language just so it doesn't fly in the face of something else that you may have read. But technically it's a three-stage process, because in between the pre-adverse action letter going out and then the adverse packet going out, there's a waiting period. So we could consider that a third step, right? And so basically after the pre-adverse action goes out, the employers go into a waiting period. Employers must wait 5 business days at a minimum after sending the pre-adverse action packet. Let's call it a packet more than a notice, because it's got multiple things in there, including the notice, to allow the applicant time to file any dispute that they may feel is necessary based on discrepancies within the report. Okay. What's interesting here is if you read the language or read any other adverse action documentation, it sometimes will touch on the fact that the Fair Credit Reporting Act, the FCRA, is relatively ambiguous in terms of how long is the appropriate time to wait. Okay, it actually literally in the language of the Act says a reasonable amount of time. So it's typical of probably a lot of regulatory language. It's very gray. It's very ambiguous in what it's how you follow it, right? So what happened was the Federal Trade Commission, some of their staff attorneys wrote an opinion letter, and you can view that on the FTC's website, and basically they came along and said, okay, it says a reasonable amount of time. We're going to lay down that we feel like a reasonable amount of time is 5 business days at a minimum, because we're the ones that enforce the Fair Credit Reporting Act. That's probably reasonable guidance to follow. So therefore, this 5-day waiting period was adopted as very much the industry standard. If you want to wait 30 days, there's nothing that says you can't do that. You just have to wait a minimum of 5 business days before you move into the next step. Okay? So, just to summarize, up till this point, we've got our report back. We've deemed something is in it that could potentially deny our applicant employment. We are generating a pre-adverse action packet that goes out to them that contains the pre-adverse action notice, the summary of rights, and the copy of the report. We're now going to wait 5 business days. We wait our 5 business days, and at this point, we are solid in moving forward with the adverse action stage. Okay, now I can roll our tenant screening purposes together with the employment screening purposes, because from here out, everything lines up identically. The only difference being from an employment to a tenant screening purpose is that the tenant screeners do not have to go through the pre-notification stage. In fact, all of the other permissible purposes listed in the Fair Credit Reporting Act don't have to go through the pre-notification stage. That is only a requirement of the employment purpose based on the Fair Credit Reporting Act. Okay, so from this point forward, we are applying to everybody regardless of what your purpose is. So here we are. Now, after our 5-day period for the employers, we're at the adverse action stage. We've got a report. We're ready to actually take the denial step. Okay, so the adverse action is obviously the actual letter that will go out that is the notification of denial of this applicant's paperwork or application, right? And so basically what the FCRA says is if you take an adverse action based on information in a consumer report, you must give the applicant or employee a notice of that fact, either orally, in writing, or electronically. Okay? That's copied straight out of the Fair Credit Reporting Act. Given that you can do it orally or electronically, that's great. You're not against the regulation in the Fair Credit Reporting Act by doing it orally over the phone with somebody or otherwise. obviously, the preferred method here would be in writing. I mean, I think it makes sense that anytime you're dealing with this type of information, communicating it in writing is always the best way to do it. But there is nothing that bars you from doing it orally or even electronically for that matter, should you choose to do so. Okay. All right. So adverse action must include, and this is again just a letter that goes out at this point, okay? This adverse action notice that goes out must include the name, address, and phone number of the consumer reporting agency that supplied the report, in this case hopefully being TruDiligence, right? It must secondarily include a statement that TruDiligence or your consumer reporting agency did not make the decision to take the unfavorable action and cannot give specific reasons as to what it is, okay, or what the reason for the denial was. And then finally, it must include language that gives the applicant a notice of their right to dispute the accuracy or completeness of any information that TruDiligence furnished, and that they can get a free copy of the report from TruDiligence if the person asks for it within 60 days, okay? So our adverse action letter goes out. It's a single-page letter, most likely, that simply just says, you have been denied employment and or tenancy or whatever benefit it is that you're attempting to obtain based on the contents of a background check report that was drawn through TruDiligence, okay, and or XYZ company, and give them the name and address and phone number and contact information for the background check company, right? It also needs to say something to the nature of TruDiligence did not make the decision to deny your application based on the contents of the report, and therefore are not able to discuss with you the specific reasons why the action was taken. In layman terms, you all are the ones that made the decision to not employ or place for tenancy the applicant based on the contents of the report, so you're the ones best suited to explain to them why the burglary charge from 6 months ago caused them to be denied, right? TruDiligence is not in a position to necessarily talk with them about why that was in contrast to your particular policies, right? That information is better communicated by you. And then finally, and in fact, a lot of those adverse action notices will say something to the effect of, if you want to dispute the accuracy of the report itself, contact TruDiligence or the consumer reporting agency. If you want to discuss the reasoning behind the information being against our placement policies, then call us directly, right? And so that might even be addressed in the language of the adverse action notice, so that your applicant knows which path to travel down depending on what action they want to take. And then again, finally, we need to make sure that that adverse action notice gives them the right to dispute the accuracy of the information and to get a free copy of the report within 60 days by contacting TruDiligence if they so desire to have that report copy. Okay? All right. So let's talk a little bit about the dispute process, okay? This dispute process can happen either during the waiting period between the pre-adverse and the adverse stage if it's an employment purpose, or it can happen any time after the adverse action letter has gone out. Just because that letter has been sent and you may have closed down the forward movement of their file in your organization, that still doesn't stop their ability to come back and dispute the information, okay? So I think it's important that we talk a little bit about this dispute process, because it is a necessary part of the adverse action process, okay? So first of all, the applicant can file their dispute either with the employee/landlord, depending on your purpose, or TruDiligence directly. Obviously, if they're disputing the contents and the accuracy of the report itself, they need to be put in touch with TruDiligence, because that falls in our basket. So I would think that anytime you get a dispute, if the dispute comes to you directly from the applicant, your best course of action would just simply be to indicate that that dispute process is handled directly by our background check company, and here is how you can get in touch with them, right? More than likely, at this point, they've already received their pre-adverse action notice or their adverse action notice, so they should know that. But if they call you, or make contact with you, put them in touch with us, and we are very happy and very versed in walking them through that process. But just recognize that they can start that process down either avenue. Doesn't matter. Okay. Secondly, if a dispute is filed, TruDiligence has 30 days in which to complete a reinvestigation at no additional charge to the applicant. Okay, so the clock starts ticking for us and you, but mainly us, when we get notified of that dispute by the applicant. Okay, and we then have 30 days in which to complete a reinvestigation of the information that the applicant is wanting to dispute. Okay. Is it going to take 30 days? No. I mean, we handle reinvestigations, however rarely they may occur, with the utmost priority, right? When you've got an applicant that is questioning the validity or the contents of a report, there's probably nothing here that takes a higher priority than that. And so, yes, the FCRA gives us 30 days. You know, they are not going to take that long to reinvestigate, okay? If the reinvestigation results in a change to the report, an updated report is obviously distributed to the applicant and or employer or landlord, I probably should say as well, right? It just depends on who you are, right? But either way, if the reinvestigation that we go and we find something that was reported inaccurately, or the source of the information had something misidentified and that followed through our report, and it ended up causing, you know, the possibility of a denial, if anything changes, we have very, very specific documented policies that we follow that are outlined in the greater detail of the Fair Credit Reporting Act that we follow in terms of the reinvestigation. Okay, so if it results in a change, obviously everybody is updated on that change, and then the applicant and client can then move forward. Okay. Something else that I thought is just interesting to point out is that TruDiligence may terminate a dispute reinvestigation at any time if it's deemed to be frivolous. You can't only imagine the calls a person takes in this kind of a situation with applicants that might be a little bit less than scrupulous and are giving you quite a woven story about something, trying to get themselves out of some criminal record or other derogatory information that might be showing up in a report. Okay, so, you know, we handle all of it with the most seriousness of nature. You know, we don't deem anything as frivolous typically, but in the event that it is just obvious that somebody's yanking our chain and just trying to get out from under something that may otherwise be legitimate, obviously we have the ability to terminate that reinvestigation if we deem it to be frivolous. Okay, and then at that point, obviously everybody's notified that it was terminated, and it just ends at that stage. Okay, so this is really important, okay? Here's a hint that I put on there, and really what it says is that empathy goes a long way in avoiding lawsuits, okay? One of the reasons I picked adverse action as the topic of the next webinar in our free series is because it is the second, probably the second most litigated area of the Fair Credit Reporting Act anywhere in the country. The adverse action process is so highly litigated. There are so many lawsuits that are filed in the adverse action realm for companies, either employers or landlords or background check companies, that are falling down in this process, that it's just will make your head spin if you were to review some of that case law that's out there. So I just think this is a really important thought. You know, if it were me, and is me when they're calling the background check company, have your best customer service people handle any dispute contacts, right? If the applicant feels like they've got someone on the phone that understands that they've got a concern and that they're very afraid that that may inadvertently get them denied for something that they might otherwise be eligible, and they are met with some sort of compassion and empathy for their situation, the next call that they make after they hang up with you is most likely not going to be to their high-powered law firm, right? And so I think that goes with anything in this realm, but really it's just, I heard somebody say something similar to that at one of the presentations we went to a long time ago on at the NAPBS on adverse action, and I just thought it was really valid. I mean, I think that goes with anything. That, if you've got somebody that you feel like is listening and addressing your concern, the chances of you potentially filing a lawsuit and or escalating it certainly gets minimized. So just give that some thought in terms of when you're dealing with applicants that are in a dispute process. I would just say handle that with kid gloves, as they say. All right? Okay. So let's talk just a moment about record keeping, because I think it's really important in this process because it is so litigious, right? I mean, we've all got to make sure that we're covering ourselves, as they say, in this situation, right? So, what it falls back to is everybody says, so what are the three most important words when you're talking about real estate? I think anybody could answer that, right? It's location, 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 right? Well, here, what do you think it is? I think anybody could probably answer the question, but it's document, 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 right? So when an adverse action process is kicking off, be a two-stage process or a one-stage process, start an audit trail file, right? It's so terribly important. Document, document, document. Document why the action was taken. Document when you got the report back. What generated the action in the first place, right? Document when the pre-adverse action letter went out, timestamp your log so that you can produce that for a court in the event that you had to. Document, did the applicant, if it was an employment purpose, respond over the waiting period, the 5-day waiting period, or not? If they did respond, what was the nature of their dispute? Did you forward that to the background check company? Who's handling the disputes? I mean, the list could go on and on and on. When did the adverse action packet go out? Did it come back undeliverable for some reason, right? There's so many things here that you can picture should you or your legal team be standing before a court trying to validate that you followed the regulation to the letter of the law. Document, 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 right? Okay, I think it's pretty straightforward. All right, so starting to wrap down just a little bit. I always like to do some takeaways just because I think it's really important just to kind of wrap a lot of what we're talking about down into some really concise thoughts, right? And so I've got 4 takeaways here that we're going to burn through. First of all, the most important takeaway, one of the most important takeaways is that if you're using a background check company or other consumer reporting agency, right, to prepare consumer reports, and the consumer report returns information that is going to cause you to take adverse action, you must follow the adverse action process. There is just simply no way around it. Don't try to weasel out of it because you're going to get yourself sued if you're dealing with an applicant that is savvy at all in what's going on out there in the industry. Okay, again, the sub-thought here is if the adverse action is being taken based on something that you did internally, some investigation or data that you developed internally, then you don't have to develop the adverse action process or implement it at that point, right? Only when the information comes through the background check company, okay? Secondly, depending on your purpose, very, very important that the employment people out there understand that it is a 2-stage process for them. 3, if you count the waiting time, right? Pre-adverse, waiting, adverse. And our tenant screeners, that it is a single-stage process, right? A lot of tenant screeners don't necessarily understand when we do our consulting with them that they are subject to the FCRA and that adverse action applies to them. So I can tell you definitively it does, and there is plenty of case law to back that up. Okay, I do want to touch on one more point here that I should have thrown on the slide and I didn't, but that is very important. The Fair Credit Reporting Act, let's talk about the employment realm for just a moment. The Fair Credit Reporting Act does not make a distinction between employees, volunteers, independent contractors, or some other category that you may have roaming about your facility. As far as the Fair Credit Reporting Act is concerned, it's all to determine their ability, that applicant's ability to move forward in a process with you. And so that is a very common question we get. Well, the person's not an employee. They're a 1099 contractor or whatever. Does not matter. In terms of the Fair Credit Reporting Act, you need to follow this process to the letter of the law if you're going to deny them. And volunteers, independent contractors, any other classification you can think of, the FCRA does not carve out anything special for those subclassifications, okay? Third, documentation, right? Every step, every action, every date, every response. It is just so terribly important that you're logging what's happening in this process, right? And finally, I think this is really important. Get it right. As I said earlier, there's substantial litigation surrounding this entire process, and I've cited a current case that is pending in the federal court for the Western District of Washington. Mr. Williams against Amazon. The reason I cited this case is because Amazon is a giant that everybody is familiar with. And I think it goes without saying that if Amazon can get this wrong with teams and teams and teams of high-powered lawyers running around trying to protect them, so can we. So be very, very cautious in your adverse action processes because, again, as I mentioned, it is terribly, terribly litigious. Okay? Someone might ask, because I mentioned it's the second most common area of litigation within this realm of the Fair Credit Reporting Act. Someone might ask, what's the first? The first is in disclosure and release processes. And I can't give you an exact number, but the number of lawsuits that are filed as a result of breakdowns in the disclosure and release processes and those that are filed in regards to the adverse action are they're probably at a 100-to-1 ratio, with 100 of them being disclosure and release processes and one of those being adverse action. But there's still a tremendous amount of litigation in the adverse action process. But again, the only thing that outweighs that is the disclosure and release processes. And in fact, I think that will probably be the topic of our next webinar, but I would encourage you even just now as a real quick sidebar, if you've not reviewed your disclosure and release processes recently, please do so. It is so critically important. If you're not using one of our releases, if you're using one designed internally, please make sure it's compliant. If you're using one of ours, make sure you've got the most recent version. If you have any questions, call us and talk to us about it. We'll make sure that you've got the right stuff in play because that disclosure release process is the highest area of litigation running at the moment. Okay? All right, so I want to talk just a moment about a couple of resources. First of all, I will mention as a resource that this webinar is being recorded, as they all are, and they will be available, and it will be available in our knowledge base within the next 24 hours or so. So don't forget about our knowledge base as a resource. If you have a colleague or someone that you feel like could benefit from hearing this information and you just want to refresh it, I'll get it converted and we'll get it, our tech team will get it loaded out there as quickly as we can, hopefully by end of day tomorrow. All right. Other resources, so with that thought, you don't have to write these long web addresses down. Obviously, they'll be made available to you. But there's just three really good resources here. Obviously, the first is a link to the Fair Credit Reporting Act directly, which is coming right off of the FTC's website. It's a PDF document that's several hundred pages long of regulation, but if anybody really wants to dig into the nuts and bolts of that, obviously there is a link directly to the Fair Credit Reporting Act. Okay. The other two are actually in some ways more useful. This is an excellent document that was written for employment purposes and another document that was written specifically for tenant screening purposes that the Federal Trade Commission has published. And you can browse to them easily if you don't want to pencil down this entirely long URL, but ultimately it's all on ftc.gov and it's in the Business Center. And so there's a link there for Business Center. And if you go under guidance, There's a fantastic resource using consumer reports, what employers need to know, and using consumer reports, what landlords need to know. Okay, and so just excellent resources. I would encourage anybody to run out there and just take a look at those documents, because they've got tips, they've got tricks, they've got step-by-step instructions, they've got guides, and that's coming straight out of the horse's mouth, as they say. It is the FTC primarily that pursues enforcement action for violations of any of this that we're talking about. So the better you converse yourself on their expectations, I think the better, right? And obviously don't hesitate to ever give us a call if we have any questions. Okay, so in general, that is kind of the end of my formal presentation. So I'm going to pause here for just a second, and I'm going to take a look over here and see if we have any questions that anybody has asked, and I'll be happy to run through those. And then I have a couple of closing thoughts for you as well. So bear with me just a second as I try to get my question pane open. Bear with me 1 second here. So, hang on a second, let me go through here. All right, so an excellent question. There is several people that have asked, basically, can you do this for us, or are we required to do this internally? Okay, fantastic question. So the answer is it can really be either or, okay? So you are not required to outsource this adverse action process to us or to your background check company. You are certainly able to do it in-house, okay? So let me approach that piece first. So if you're going to do this in-house, I'll show you a couple of resources we got here. Bear with me just a second. I need to get my website up here over and above the PowerPoint. If you go to our website, and for those of you that don't know, underneath resources is where the knowledge base is, and also the download forms page, and a lot of other valuable resources you can use. If you go to the download forms page, on the download forms page is pretty much any form you would ever need to manage your employment screening program. Background check releases, just a plethora of information out here, right? Under compliance forms is a sample adverse action notice for employment purposes, a sample adverse action notice for tenant screening purposes, an FCRA summary of rights, and a pre-adverse action notice, right? And so all four of those documents that are out on the website can be used. Feel free to go out there and pull those down anytime you need. Make use of them any way you would like. They are designed to be FCRA compliant. They are basically designed to be templates where you could open it up. We distribute them as a PDF, but you could obviously convert that to Word. You fill in the blanks, and you can distribute it at that level. So to the question, yes, you can do this internally, and we even give you the resources there if you want to do that. Okay. For those that say, especially from a documentation standpoint, right, I don't want to take responsibility for all that. Can you do this for us? All right. What I'm going to do real quick is I'm going to log into the website, and assuming that the greater majority of you that are in attendance of their clients, you have access to this. If not, you can give us a call and we can discuss it a little bit with you. But ultimately, when you get logged in, this is a page that you all are familiar with. If you go to the results section, on the results page, for those that have never really paid much attention to it, there is this little letter icon over here on the right-hand side, okay? On each person's result entry, this little letter icon allows you to, when clicked on it, open up the adverse action letter service. And this is a fulfillment service that we offer. And so once your report is completed, it will not allow you to take adverse action on a partial report. But once adverse action is the report's done and you've decided you're going to do adverse action, you can request that right through clicking on the little letter button icon, right? And then here you have the ability to determine, do you want to send a pre-adverse action letter? Do you want to send an adverse action letter Obviously, we give you the ability to break that out, as only employers would use the pre-adverse. The tenants will go directly to the adverse, or both with that 5 business day window in between, right? So you can entirely control here which of those options that you want to do, right? What date do you want the letter to go out? So we've got a little pop-up calendar here that shows you the available calendar. You can pick what day you want those packets to be sent out, and then it pre-populates the applicant's address from your order. If you didn't give us an address at the time of the order, then obviously these fields are going to be blank. You'll just have to type them in for us so that we know where to send the letter to. So it's really simple. If you pick a date and everything else is pre-filled and say you want to do both, and you click on submit, it will tell you that the request has been submitted and you have now fulfilled your adverse action fulfillment through that order. So at that point, then the order is coming across to our side. We will generate the appropriate packet based on your selections there and get that out in the mail. We'll document everything that we've done and can produce that anytime that audit trail is needed. So it's a good way to do that. Okay, so let me go look at our questions again. And let me see if there are other ones here. I had several people that asked that question. Bear with me just a minute, and I'll go through them here and see if there's anything else here that I can help with. Good question. So the other question here is, in the adverse action letter, do you have to basically share what component of the report caused the adverse action? And the answer to that is no. You don't have to outline that in the actual adverse or pre-adverse notice. You just simply have to state that potentially derogatory information has been found that may potentially cause a denial if it's the pre-adverse, or has caused a denial if it's the adverse stage. Okay, so no, you don't have to specifically give the detail as to what it is within those letters. I will touch on a separate component of that, and that is the EEOC, Equal Employment Opportunity Commission, on an employment side, published a guidance document back in 2012 with regards to the use of criminal records and other information in an employment screening decision. If you haven't found that document or read that document, it's also on that resources page that I just showed you on the website, and if you just search EEOC guidance in Google, it will come right up for you. In there, they describe, in addition to the adverse action process, the types of information that they feel like you should be giving the applicant in the form of an assessment, an individualized assessment, they call it, when you are evaluating the background check report, right? And so I won't get into that too deep right now, but they give some very specific guidelines in the EEOC guidance from 2012 about how to evaluate a report and what kind of points you should be documenting when you're doing that assessment, probably before you even get to the adverse action stage, right? And so that way you've pretty much already documented that internally, and at that point can move forward with the adverse action process. So I'll encourage you to take a look at that. Another good question, do I know what percentage request a free report? You know, it's interesting. I would say we don't get very few, maybe 1 in a few thousand, quite frankly, that ask for the free report after the adverse action has been taken, okay? We get a higher percentage of copies of their report during the actual disclosure process, right? As you all know, in an employment realm, your disclosure and release forms have to provide, in certain circumstances and in certain states, the ability for the applicant to get a free copy of their report, all right? We do find applicants that ask for it very, very frequently in that disclosure stage at the beginning of the process, right? And so we send it out as a matter of complying with that regulation when the applicant has requested a copy of the report preemptively. Beyond that, into the adverse action stage, again, it's one in a very, very small percentage, really, that that actually ask for it, beyond the adverse action stage. Okay. Yes, another question there, which we touched on. Can you get a copy of the presentation to review with our HR people? Absolutely. I'll make the PowerPoint available, as well as the recorded version of this webinar out there on the knowledge base, where I indicated, again, within the next probably 24 hours, as I can get it converted and ready to go. Okay. Good question. Should we notify you if we decide to take adverse action and send a pre-adverse action notification? I would say yes. I mean, there's nothing necessarily in the regulation that requires that, but we're obviously running on the assumption here that you are going to be doing that internally and not using TruDiligence for that. And so I would say yes, only because the applicant may very well have a desire to have a discussion with us, and it would be really helpful for us to understand that this call is coming in response to a pre-adverse action notice and not just in some sort of general form from the applicant. Okay, so if anything, it would just help better arm us for that conversation with your applicant if you would let us know. So yeah, I mean, just from not even a policy standpoint, but even just more procedurally, if you could notify us that that action is being taken, it will certainly help us to better handle those situations as they come in. Okay. Another good question. Can I confirm, basically, is there an extra charge to generate the pre-adverse action packets if you use our fulfillment service to do so? I'll say yes, there is. It's not really included in the base cost of the background check report that we prepared for you. And in general, it may vary a bit from client to client based on some volumes, but ultimately the base charge for those are $3.50 per package that we send. And quite frankly, we're just trying to get our costs somewhat covered in paper and envelopes and postage and everything else that is going into preparing those packets as they go out. So yeah, we do charge a small nominal charge to fulfill that service for you if you would like us to do it. And hopefully the convenience of having us do that and also maintain all the documentation would certainly be advantageous to you for the fee charged. Okay. Okay, so there's another question here that I will summarize just a little bit, and that is, if someone lies on an application, okay, in the pre-stage, pre-background check stage, we're assuming at that point, right? We haven't even ran a background check yet. So if someone lies on their application and the consumer report reveals something that is likely in contrast to what they wrote down, do you have to do an adverse action letter? Because you might be taking adverse action based on the misrepresentation. What's kind of the best path? I would say at that point you don't have to do adverse action, because ultimately, if the reason for denying the person was based on a misrepresentation on their application, then it's probably likely not going to result in a denial based on the background check report. I can actually, as I'm thinking that through, quite frankly, can see that going both ways, because also the other argument might be that you obviously didn't know that there was some sort of misrepresentation until you got the background check report back, and so it was based on the contents of the background check that brought the lie to light. And so, in a conservative approach, honestly, I would really say that I think a legal argument could be made by a defendant that it was because of the report, You didn't know about the lie until the report was generated. It's based on the contents of the report that brought the lie to light. So rethinking what I maybe just said a few minutes ago, I think that in a conservative approach, I probably would recommend adverse action in that situation. Because I do think, again, an argument could be made that that it was the report that brought that to light. And so, again, just from a protective stance, I would say yes. Always err on the side of probably conservatism in this particular situation, and so send the packet. Absolutely. Okay. Yes, I have a question here that can I share the link to the EEOC? I can certainly get that available and maybe get that added onto the references. I will show you also on the website if we go to the resources. Bear with me just a second. I got to get myself to the right place here. If we go to the download forms on the resources, it's actually right here also. So TruDiligence.com/download forms or resources, download forms. Under the compliance forms section, it's the very first document there, 2012 EEOC guidance. Again, a fantastic read, okay, in regards to where the EEOC stands in this entire background checks for employment purposes realm, okay? All right, well, I think that pretty much brings us to the end of the questions. It doesn't have to end here. You know, we are certainly always available for any questions unique to your situation. You know how to get a hold of us. All of our contact information is on the screen. We're available by phone, by email, through live chat on the website. You know, we're very happy to speak with you about your specific situation, or if there are things that you think about in the form of a question beyond this webinar, we're very happy to speak with you about anything that, that we can help you with. So with that said, I'll thank everybody for joining today and encourage you to keep your eyes out for notification on our next free webinar, which I think will probably be on disclosure and release requirements as outlined in the Fair Credit Reporting Act. And we're endeavoring to run these, about every 60 days. So I would expect probably maybe sometime in early October that we will have that available, if not before. So thank you everybody for joining, and have a wonderful afternoon.